either to start the process, agree on this and the other. We will not move until there's an interdict from a court for us to do something. Would then mean that all the steps of the way had to be followed. Part A, Part B, appeal, Part A, Part B, appeal. I don't even know how many times over and over, getting us to where we are now. Correct?
I'm not sure what is the question. I agree with the narrative that there has been these steps. As far as I'm aware, I can't vouch for details, but I'm aware of that.
Okay, let me ask it differently. Yeah, let me ask it differently. This amount of money, which I've estimated, I'm saying, is made up of Part A of the 2020 case, Part B of the 2020 case,
Recording
and
in
the
progress.
Constitutional Court hearing of that case, and then Part A of the recent case of this year, Part B of that case, and now the Constitutional Court litigation around that case, both of which, those cases in the Constitutional Court, in both cases, the President or the National Assembly had lost the case and appealed all the way up until the Constitutional Court. That's a fair summary of your understanding? In other words, they were the appellants in the Constitutional Court.
In the latest matter, yes. I will have to check exactly who was the parties, but it's a fair summary.
Thank you. No, I can take it from me. We were the appellants and we were the respondents in the first case as well. This is the case in respect of which eventually came up with the decision that the public protector should be legally represented. That's why I'm here, so you can believe that that's what happened. Accept that?
Yes.
Yes. So that's what, okay, that's fine. I think that covers then, at least those are the major 6 steps, or 5. The 6th one is coming in 2 weeks, which form the large bulk of that amount of money that the taxpayer has had to expend. Correct?
Yes.
Right. Yeah, that's fine. And as I say, we don't know the end of it because this process is still continuing. And so is that litigation in the Constitutional Court as we speak, at least as of today, correct?
Yes.
Thank you. Then this then relates to the issue of okay, no, let me do it like this. Sianejo attorneys. The letter that I'm talking about where the public protector was pleading that this matter be resolved, which could have avoided all the tens of millions of rands, was actually ironically written by Sianejo attorneys, but it was not, as I say, the attitude of the speaker was that what you have to do, go to court. But my question to you is that at that point, neither the public protector nor Sianejo attorneys would have known that the response would be negative and lead to all tens of millions of rands spent. Correct?
I suppose Advocate Mpofu, Advocate Power.
Chair, I fully appreciate that Advocate Mpofu is steeped in that litigation. But as evidence leaders, we've not been involved. We don't know what letter is being referring to at all. We possibly just get a copy of the letter. I know the chair might have it or the committee might have it, and but Advocate Mpofu's probably got it right there.
No, thank you, Chair. That's a fair request. Yes, no, the Chair has it, but in wearing another cap. And the Parliament has it also. The Speaker has all that correspondence. Chair we will oblige and will get it from the records specifically for this process. And that's why, Chair, I was asking in general terms.
Okay.
I was aware of that, but I think it's a fair request.
That's fine.
Thank you. Okay, assuming again that such, I'm not making it up, that such correspondence exists, and I accept that you haven't seen it, Mr. van der Merwe. The simple point I'm making is that neither the Public Protector's Office, and I mean someone in your position, I know at that stage you are not in the legal department, but neither you as the client nor your attorneys would have known that the evolution of the matter will end up to what I've described, into a 100 million spend matter, when the brief or the instruction was given to Sianejo. Correct?
Again, I'm just trying to contextualize it because it will be highly speculative to say that what was expected at the time. Looking at it now, I can assume that was the thinking, that it would not have been expected to escalate to this matter.
Thank you. No, I'm happy with that. The point I want to make, which I'm driving at, which I'm going to argue at the end, Advocate van der Merwe, is this. When we are told that Sianejo got the lion's share of the work, in reality, the cases that I've described to you, 6 of them, which all, well, 2 going to the Constitutional Court, those are aftermaths of the same instruction. In other words, there was an instruction in 2020. Nobody would have known that sitting here in 2022, we're going to be now on case number 10. I'm not even counting the other tentacle cases of that very same instruction. It's one case. It's not 10 cases, but that case has resulted into 10 cases and 100 million rand. And I'm not putting my head on the block for the amount. A lot of money. You get where I'm going?
Yes, Chair. In this instance, because I've put some, as the legal, put some facts in writing to Mrs. Sianejo, I would have to qualify it, though it is arising from the one matter. Ex post facto, I had an issue with the way whether every mandate and instruction was properly in terms of governance process, but I think you're not referring to the internal governance procedures. You're referring to the matter as arising from generally the same course of action.
Yes. Okay, fine. I don't even want to go into that. But all I want to explain to the committee, remember, the committee members are public representatives. They just see some big figure. I'm trying to put that into perspective, that actually it's one case. And let me end it like this, maybe. Would you agree that, in your experience now, the extent of which I don't know, but would you agree that if a complex case like that, let's assume tomorrow someone were to say, no, Sianeho attorneys must move from that matter, that entire institutional memory of the same attorney who had been handling it, the new one would probably cost millions, but just before you even start, because they would have to familiarize themselves with the case from February 2020 up to now. Is that a fair assessment in your general experience?
Yes, as a general proposition on a complex case, that's correct.
Yes. Just as I know there was a false accusation about withdrawal a few weeks ago. But just as if, let's assume there was such a withdrawal, if a new team were to come in now into this inquiry and have to go through the 20,000 pages of paper that has been generated, that would cost, as I say, probably millions and millions of rands before they even write even one letter, just from familiarizing themselves. Assume attorneys, one senior counsel, one junior or two juniors. Would you agree?
Yes. Unfortunately, I as a general proposition, yes, unfortunately, I'm wearing two hats as the person who would have to foot the bill or manage the expenditure as well. So I would have to, if that subjected fault is not occurring again.
Okay, no, I understand that. I'm just saying any lawyer should be able to answer that. And in respect of any matter, quite frankly. The point I'm simply making is that the fact that it's a complex matter just makes it worse. Yeah. The general proposition I'm making is that if you have an attorney and a team of counsel who are familiar with a particular matter, and you change those teams somewhere halfway or at any stage, that entails an extra cost, because the new team obviously has to familiarize themselves first. Correct?
Yes.
Yes. And so you can multiply that. If it's a complex matter that has already cost you 20 million, it might cost you more. But even if it's a small matter that costs 100 rand, that principle applies, correct?
Yes.
Thanks. So, right. Now that we've got that in perspective, and I don't want to go through the same painful blow-by-blow experience. The second matter of the same magnitude, where the instruction went to Sianeho, was let's call it the Godan matters, correct?
Yes.
And in respect of those matters, what I've just described actually is chicken feed, because those matters went to the High Court, Full Court, SCA applications for leave to appeal, Concord application for leave to appeal. I'm not counting the small matters in between, but let's just say both of them, at least the Pillay, so-called Pillay matter and the Rogue Unit matter, ended up in the Constitutional Court. Another one of them, the last judgment was handed down today. Correct?
Yes, that's correct.
Yes. And again, that's a series of, it's the same instruction, which started in 2019. Was the last election in 2019? Yes. Which started in 2019, and as I say, it culminated today. in a lot of money spent for, I remember in one of those matters, I was leading one team and there were 4 teams, I think, against me. One was representing Mr. Pillay, one was representing Mr. Kodan, other one was representing Mr. Mahashula, and I don't know the other one was representing, but maybe there were 3. But each of those teams had senior counsel, attorneys, and all sorts of people. From 2019 up to now, you can just imagine the astronomical cost on all sides would also come close to the 100 million figure, correct?
Yes, I can speak about our expenditure there.
Fair enough, yes.
Say
Yes, but
16
you
million.
can extrapolate. Okay, let's assume we were, and when I say we, I mean you and I are now on the same side. Let's assume that we were one of those 4 teams. Would my estimate be not reasonable?
Yes, I can't say the hundreds of millions, but yes, it's. If you look at our expenditure and think this is from 4 sides, then yes, it can come close to, I think, 80 to 100 million.
Yes. And again, the only point I want to make now, looking at our point of view as the public protector's team, so to speak, is that that instruction was also, if you like, a single instruction. Okay, I know it was 2 because the cases were interrelated, but 2 interrelated instructions basically dealing with the same parties on both sides, correct?
Yes, correct.
And what is more about that one is that, unlike the first one, which I've demonstrated was instituted reluctantly by the public protector after being rejected by the speaker with overtures of cooperative governance. In the case of the second big case where that much money was spent, actually, this was a case brought against the public protector, not by her, correct?
Yes, I've been thinking about this because in my evidence, I was referring to the fact that Mr. Gordon was the subject of a lot of investigations against the PP. So a simple answer is difficult because I have to speculate who initiated what. I haven't drilled down in whether the case was brought against or by the public protector. From my perspective, because I wasn't involved in the litigation itself, I just have an overview of the parties and the costs that were incurred.
Yes,
I can't comment on that.
Fair enough. And actually, my question is too broad and to some extent inaccurate because of its broadness. So I'll break it down. You don't have to speculate. In so far as it is a review, it should follow as a matter of logic that the public protector was not reviewing her own report. So it must have been somebody else who did the review, correct?
Yes, she would have been the respondent, yes.
Yes. So there's no doubt about who initiated to the extent that my question was inaccurate, let me correct it like this. The qualification is that, of course, once the first set of litigation happened, it would have been the public protector who appeals and takes the matter further. So I was just talking about the initiation of the matter, but it's subject to that qualification. Do you accept that?
Yes, I just have to check the facts in terms of the original application. related to that, the one with Mr. Lodlo and the PPSA, but I don't have enough facts to say who initiated, but there is, as far as the review is concerned, yes.
Yes, thank you. Okay, now, I was going to clarify. Okay, that qualification is, I'm happy with it because it saves me from having to testify. Okay, fine. Now, all right, so let's then pack all those, because that is the perspective of all this. Instead of just putting big figures around, we start seeing them in perspective. So would you agree, and I'm not married to this because I've not done the exercise. Would you agree that that whole lump sum of, I think it's 147 million or whatever, over the years that we're discussing, a big chunk thereof, and I'll give you the percentage tomorrow, would come from those two cases that you and I have just discussed?
Yes, according to the figures at my disposal, it's 16 and 19 million. So it's about 35 million.
Yes.
Let's
just say, yes, no, fair enough. Let's just say there's no other combination of two cases that would come up to 35 million. All the other amounts would be split into smaller chunks, correct?
Yeah, the closest to that is the Absa CIX matter.
Yes, correct. You're right. The third, in that series, if you were to say which are the three big matters in that spend, yes, I agree with you. It would be National Assembly, the Godan matters, and Absa matter, correct?
Correct.
Right. Well, which then brings us back to the Absa matter, where you gave the advice and part of the recommendation for what ultimately caused the furore, which was the proposed amendment of the Constitution, in the manner that I explained, in the indirect manner that we explained earlier.
Chair, I have to qualify that because I know that's the narrative that Chair wants to present, but as I said, I've put it in perspective exactly how it came about, and to in the end say that I gave the advice based because the only narrative that would have been close to any information that the PP would have had in mind was the fact that she wanted to amend or review the mandate of the Reserve Bank, and I was working the only sentence, and I've looked at it, where I made any suggestion before the Absa report was I followed an alternative line of argument based on the need for oversight by Parliament in terms of Section 55 of the Constitution and the EFF constitutional mandate. I am, however, hesitant to suggest even any reference to suggest that I gave the advice that led to that. I can't say what the PP, what informed the public protectors, but all I'm saying is that one sentence is unlikely to have constituted the advice that led. If that is the proposition, I'm not agreeing with that.
Right. It is the proposition. Okay, and then that means we have to do it the hard way. All right. Your involvement, would you be comfortable if I say you played a significant role towards the proposal for the amendment of the Constitution? I don't put it higher than that. I'm not saying it was your sole baby, but that you played a significant role. Happy?
No, I can't say that because that evidence, that research was not even in the frame in the terms of reference when that recommendation or that remedial action was taken on the amendment of the Constitution.
Yes. Mr. Van der Merwe, please, we spent a lot of time on this.
Yes, and we don't agree.
I accept, okay, in case you've forgotten, I accept, ACCEPT. I accept that your document was only given to Mr. Kekana a day after the report. Can you believe that? Do you accept that yourself?
That's not in dispute.
Okay, good. So let's not go there. I have demonstrated to you that in spite of that, your views on this had been made known at least 2 to 3 months before the release of the report. Let's forget the Kekana thing. Do you dispute that now?
Yes, not views, a single view that if the PP wanted to pursue the amendment of the Constitution, we have to follow an alternative route. It's not a view, it was a proposition of the route we needed to follow.
Good.
It was not on the merits of a review or the merits of any of the matters. It was just an avenue.
Yes, let's call it an avenue, a proposition, whatever word you like. That avenue and proposition, would you agree that it contributed to the ultimate decision?
No, it can't. No, it can't, because we were proposing to write to the Constitutional Review Committee with a broad research paper based on our findings to propose a review. What the CIX report was to come up with wording and not to make the proposal for a review, but actually to direct the amendment of the Constitution. There's a vast difference between what I was doing and CIX eventual. I can't see, and I cannot change it in any other way. I can't see how the single line in that email could have informed the remedial action in the APSA matter. And I'm not budging on this. I cannot see that informed the public protector's decision. It's impossible.
All right, okay. Apart from that single line, did you also draft the letter to Parliament?
Yes.
And that was not a single line, it was 4 pages, correct?
I'm verifying the letter. It's, a little bit more than 4 pages.
Okay, well, my version is 4 pages. And that will be found at page 4114 to 4117. Can you put it up then? And while we are putting it up, you and I have accepted that when you are talking about the review of the Constitution, that obviously was not just for fun. It was linked to the review, and it's changing to suit with whatever the public protector wanted to achieve, correct?
Yes.
Right. Now, if we understand then the word review in that broad sense, then your letter, let's look at your letter. This is the public protector asked you to draft this letter because of the work you had been doing on this matter, correct?
No, I draft this letter as an alternative, like I said in paragraph 5, because I could not execute the directive of the public protector to
good.
endorse the Ubuntu.
Yes, fair enough. So it's even better. So you drafted this of your own accord, correct?
No, sir. I drafted it as a response to the Public Protector's directive,
Yes, I understand that.
as an alternative to the directive that I was given to come up with something else that the Public Protector could consider as opposed to the risky one.
Yes,
But
yes,
whether the
Mr.
Public
Merwe.
Protector consider it, I can't say.
Yes, Mr. Merwe, I'm with you 100%. The only issue I'm saying is that you drafted this of your own volition as part of that proposal for alternatives. That's all I'm saying. I'm not saying it was your original idea or whatever. But you, Mr. Van Merwe, woke up one day and decided to draft this letter of your own volition. That's all I'm saying. Or did someone put it?
Own volition doesn't apply to this because it would imply that I drafted it just as an own initiative. I think the word volition means that it came from me. But can you still hear me, Chair?
Yes, proceed. We can hear you.
Yeah. So to put the word volition in this is not my own volition. I was executing a task. And this task was to come up with an interpretation of the Public Protector's directive. This was not my directive. It was to say to the Public Protector, if you were to do it, this is the way. It was not me putting words and advice in the Public Protector's ear about how she can do it. This was interpreting her directive and say, as opposed to the directive of just endorsing a letter, this was an alternative way. We don't even know what value. I don't even have an idea. So I can't comment to say that this was exactly the advice that the Public Protector informed the UPSA, because first of all, it's far removed from the conclusion that was reached there. These were just preemptive ideas of saying this is the alternative. So to draw any conclusion on the weight thereof, for me, it would be highly unfair on me.
Okay, let's try again. I don't know how many times I'm going to say this today, but Mr. Van Merwe, I accept that this was the original idea. It been communicated to you by the Public Protector. If you don't believe me, well, I don't know. So when I say you did this of your own volition, I'm not suggesting, as you are saying, that this was an own initiative. Not at all. But what I'm saying to you, which you cannot sustainably deny, unless if you want to mislead the committee, is that in the process of suggesting the alternatives which you did, one of the things that you did on your own was to, in the execution of that alternative route, was to write this letter. Nobody said to you, write a letter or don't write a letter. You made a decision to write this letter, correct?
Yes.
Thank you. All right. Now, in your letter then that you wrote under the terms that we have just described, you said, this is I can't remember the words you used, the proposition or the avenue that you proposed. Let's go to paragraph 1. The letter is written to Honorable Louis Nzimande, MP, and Mr. Vincent Smith, co-chairpersons of the Joint Committee on Constitutional Review, Parliament of the Republic of South Africa. Correct?
Correct.
Yes. And the subject is submission to the Joint Committee on Constitutional Review in terms of Section 45, 1C of the Constitution of the Republic, recommended review of Section 223 and Section 225. And you and I have agreed the context in which the word review is used, correct?
Right.
Right. So the review stroke amendment, or which would lead to an amendment, you then say, reference to Section 223 to 225 of the Constitution and your call for submissions, Public Protector welcomes the opportunity to make submissions to the committee on certain sections of the Constitution that we believe require revision. We now know revision means amendment, correct?
Yes.
And then you say, accordingly, the Public Protector recommends that Section 223 and 225 of the Constitution dealing with the establishment and powers of the South African Reserve Bank be reviewed for the reasons as discussed hereunder. Okay, so those two paragraphs clearly propose the review stroke amendment of Section 223 to 225 of the Constitution, correct?
Correct.
Then, okay, I won't read the whole thing. But 4.1 says it's not the purpose or intention to provide a comprehensive legal analysis and so on, but rather to draw attention to key concerns in relation to the effect thereof on accountability and parliamentary oversight as required in terms of Section 55 and 69. You and I have gone through this. This is what you call, I can't remember the word term, accountability, independence or something. You remember?
Yes.
In your paper?
Yes.
So
That's correct.
yes, called accountable independence. Correct?
Correct.
Yeah. Then to the perspective, which, and again, when I say it's your own initiative, I don't mean it was your original idea. But you managed to situate this exercise in a constitutional court judgment as follows at paragraph 4.5. You say, in the Economic Freedom Fighters versus Speaker of National Assembly, the Constitutional Court highlighted the following important aspect of the mandate of the National Assembly relating to oversight emanating from the Constitution. And then you quote from that case. Similarly, the National Assembly, and by extension Parliament, is the embodiment of the centuries-old dreams and legitimate aspirations of all our people. It is the voice of all South Africans, especially the poor, the voiceless, and the least remembered. It is the watchdog of state resources, the enforcer of fiscal discipline, and cost effectiveness for the common good of all our people. It also bears the responsibility to play an oversight role over the executive and state organs and ensure that constitutional and statutory obligations are properly executed. That's you laying the basis for the proposed amendment, correct?
Yes.
Yes. It's not the Public Protector who gave you this quotation from the Constitutional Court as the basis for the amendment, correct?
No.
Good. Then you go to 4.6 and you say that, I'm jumping the first part, Sections 223 to 225 of the Constitution are not sufficiently aligned to the constitutional requirement for mechanisms on oversight. Inter alia, Section 42 and 55, as well as the relevant constitutional provisions that refer directly and indirectly to oversight and accountability to enable the National Assembly to effectively maintain oversight over South African Reserve Bank, as well as the relevant responsibility of the Minister of Finance. That's you. It's not the Public Protector who said you must put those words, correct?
Correct.
And then you say, it is proposed that the Constitution and the Reserve Bank Act should be reviewed and revised, in other words, amended, within the presence of sound, rational, and appropriate institutional arrangements. That's the same from your previous letter. around fiscal policy and fiscal policy management and central banking for the purposes of aligning the Act with the Constitution in order that Parliament may exercise oversight over it. Those are your words, correct?
Yes.
And those words, word for word, this you do in May of 2017, correct?
June in the research paper.
No, the letter.
Yes.
Yes. The words that I've just read to you, word for word, come from that sentence that you and I discussed.
Yes.
In your paper that you gave to Mr. Kekana. That qualification within the principles of sound, rational, and appropriate institutional arrangements around fiscal policy and fiscal policy management and central banking for purposes of aligning the Act with the Constitution in order that Parliament may exercise oversight over it. Save maybe for a comma here or a word there, but that's a reproduction of the same phrase, correct?
Yes, correct.
So the fact that you gave this thing to Mr. Kekane a day after the CX report is completely irrelevant because it was already contained in your ideas which you had disseminated before, correct?
Yes, again, and I must qualify this extremely
Yes, please.
Clearly. This was a letter. I don't even, and from what I read, when I read the public protector's email, to say how, because if you say then I amended or I proposed how the Constitution should be amended, it was clearly that the PP did not read this letter because she asked me after the submission of this letter that I must make a submission as to how the Constitution should be amended. So to say that this was in fact even read by the public protector is highly speculative. I don't know. To say that this informed and then construed the APSA recommendations or remedial action is again speculative. I don't know. All you can deduct from this is there was evidence, there was an engagement between the public protector, myself, Mr. Nemaseki, and the CEO on her submission, her intended submission to the Constitutional Review Committee. Whether the public protector then decided to change course and change the wording of the Constitution, how this would then relate to that and lead to that, for me, is highly speculative. There's for me no direct correlation. I can't say what was happening in the PP's mind to say that this informed her decision. Again, just looking at the probabilities and looking at the wording that came up and the report that came to us in the think tank shortly before that didn't even have this, to link the whole exercise to saying, make a submission to the Constitutional Review Committee, but in the same time saying, I'm going to use this in the CIX report to actually come up with wording to change the Constitution. It's alerting a responsibility to something I did for a completely different exercise. Whether it subjectively or consciously affected the public protector's thinking, I cannot say. But to say that this directly led to the CIX, for me, is highly speculative.
Okay. So is your argument then, you want this committee to believe that all this that we've referred to was completely unrelated to the recommendation to amend the very same sections 223 and 225, which ultimately found itself in CX. Is that what you want the committee to believe?
Yes, and again, I say in the context, because what we are dealing with is as I said, the avenue is different. The public protector could not have derived from my suggestion to review the committee to the Constitution to come to a point where she actually made amendments. There is an interrupting sequence of events that has been presented to the committee that explains that part. to disregard that and say that this report of mine or this is the actual source of that remedial action in the CIX report, for me is opportunistic and speculative.
And the opportunist in that sentence is me? Or the
Or the public
protector?
protector. I can't say
I see.
that from my reading of the engagement we had, there was no concrete substantive submission that could have even led to a remedial action in the CIX report based on what I was presenting. An incomplete document.
Right. And would your answer be different if in the CX letter, or rather, sorry, in the CX report, the public protector had used your words and said that she recommends that the Constitution be reviewed and amended as discussed hereunder?
Yes, because then there's a direct correlation between the substance of what I was dealing with and the end result in the CIX report. Currently, there's no direct correlation.
So the difference is that you use the word the Constitution must be revised, and she might have used the word amended, which you and I had agreed are synonymous in this context. And you call that a difference?
Yes, I do, because we were not sure even if we were going to, at the end, say the Constitution must be amended. Obviously, if you make a submission to the Constitutional Review Committee, it's not just in the air, like you say, but it's not a directive. It's something to give a thought, food for thought for them to say that when you are reviewing, because they were reviewing it, obviously they were not reviewing it in the air. It was with the review to see if amendments were required or necessary, and we wanted to contribute to that process.
Yes. Mr. Merwe, let me assist you. Again, sorry, I said it was the last time, but it wasn't. I accept that in the CX report, this matter was put stronger or more directly. Okay, so put that aside. But the point I'm making is that to say that it was unrelated is fanciful. Because, yes, it might have been put differently or stronger, but it was a stronger version of your recommendation, avenue, proposal, whatever you call it. Because it relates to the same sections of the Constitution, 223 and 225. It can be completely estranged from the other exercise. I thought you had admitted that 2 hours ago.
No, sir. If you're putting again,
I'm saying there's no relationship between the two.
Yes, let me explain, as you always say, Chair. If the public protector wanted to use my expertise and evidence, they would have called me and say, because I would have had to contribute to the legal framework. A report consists of evidence, then a legal framework that motivates the standards. None of the other people involved in the report had the background information that I had. None of them could have, on the basis of a letter alone, came to any conclusion of what I was trying to achieve. I know how we operate, and I know what was the purpose of the mini think tank, and that I contributed to. If there was any hint that I was to contribute through research or through the proposals that I've been making to the Constitutional Review Committee, to the CIX matter, they would have involved me to come and explain and to put that narrative in the report, because that is the motivation. The lack of any reference, any wording of any of this in the CIX report is prima facie indication that it was not part of the thinking processes in the CIX report. If it was, again, it was not reflected in the report.
Okay. Now, again, and I'm now putting it at the level of what you want the committee to believe, which I find incredible. You know that after the release of the report, the first, shall we call it, sign of trouble came from an inquiry from the media about the so-called market reaction to the public protector's proposal. Yes?
Correct? Yes.
Sorry, I'm just looking for the... And when that happened, the public protector sent the message that it must be sent to you to respond, correct?
Correct, yes.
Why do you think she would do that? If there's no connection between the two exercises, after the release of the CX report, there's a whole hullabaloo blowing out there. There's a media inquiry, specific media inquiry from Ms. Feriel Hafaji. So you can imagine. And the public protector's reaction to this is that please send this to Niels to give the response. And you still want the committee to believe that there was no connection between the work you were doing and the CX report, correct?
Precisely. Why was I only then consulted after the fact? Because I could provide ex post facto support for whatever was said in the report. It was not contained in the report. This was an ex post facto request saying that I might have information that could assist with the media. That's all it is. I don't know to the extent of which, as I said again, just looking at the report, whatever the public protector's intention was, it was ex post facto.
Yes, sir. No, I understand that. You must understand where I'm coming from, Mr. Van der Merwe. If I don't put these things to you, and then the public protector comes here and says them, I will be correctly criticized of what you've accused me of opportunism. So I have to put what her version is going to be to you. And if you want, you can simply deny it. And the facts speak for themselves and the probabilities speak for themselves. You and I don't have to debate the probabilities. But do you understand that?
Yes, if that's so simple, then I would deny.
No, don't deny. I've not even asked you anything yet. But I'll take your denial in mind, your preemptive denial. But the fact that you are denying it makes it even worse because it means you are denying the obvious because I have not even said it here. But I'm saying to you, sir, the public protector will testify to this committee that the only reason that when this thing blew out, her reaction was send it to Niels to give the response was because there's an obvious connection between the work you were doing on Section 223 and the issue of the amendment of 223, which is the same issue issue you were working on. I accept for the record that it was now in the form of a recommendation or remedial action and what have you. But I'm not talking about that. I'm talking about the content. I'm saying the only reason she's going to testify that the only reason she referred it to you is because this was the same content you had been working on. Will she be lying if she says that? Now you can.
No. Yeah. As I said, the purpose when a media inquiry like that is received, one would try and reason it on the basis of the report. My big concern is the fact that whatever I was supposed to contribute to the media report could have been then as far as my general expertise on the subject matter is concerned, to assist with clarifying whatever queries the media had and to put matters in perspective. Whatever. That is my expertise that I was building up on the subject matter. But that expertise, the reasoning, doesn't flow from the report. That would have been just referring a matter to me as a subject matter expert, saying I can contribute to the media inquiry, which I do on a number of occasions.
Yes, no, fine. I think we'll, you and I, even if I explain this for the next 5 days, it will be on the same page. So that's fine. So let's leave that to the committee and the summary. At least I've done my duty, which is to put to you what the version of the public protector will be. Did you make any contributions to the CX report?
Yes, on the draft report, I raised a number of issues. I can take the committee or you to that.
Okay, I'll take you.
Comments.
You will find that at the report is at 4185.2. Starts at point 1. And it's still your evidence that there was no connection between the two exercises, correct? The compilation of the CX report and this other work you were doing, correct?
Advocate Mpofu, can you just repeat that page reference you?
It was 4815.1. That's the beginning of the document. Please answer the question, Mr. van der Merwe.
That's correct.
Okay. Yeah. Well, I put it to you that you are deliberately misleading the committee. But let's try and demonstrate.
Give me an opportunity to respond to that, Chair.
Yes, please, sir.
Yeah, I deny. If you look at the inputs I made and the work that the inputs to the report, I've explained in detail how it came about. So to say that I'm deliberately misleading the committee is not true.
Yeah. Okay. That's fine. Then let's go to your comments. 41. Did you find it? It's 4185. Is that series 4185.3?
We're not.
Pardon?
Let's switch it off.
4185. Let's just go to 4185, which is the professional fees. Then I'll know whether we're on the same document or not. This should be, as Advocate Bowles, should be on the bundle of documents that not the latest bundle you created for us recently. It's the original. You know, when I read 4114, for example, it's from the same series. Excuse me. And when I read 4114 to the witness, we were on the same page, as it were. What's your NVM 12 4178?
Okay, we're getting there.
Yes, thank you. Page
4.19.
Are you winning? Slow tap. Okay.
um 4185. Yeah, that's the one. The cover is 0.1, yeah. That's that one. And then the rest, I was now going into 4185.3. Can you put that up? So, Mr. Van Merwe, is it then correct that your involvement in the CX report was more than that meeting that you missed when you were in hospital of the mini think tank? You actually contributed to the document.
I testified that when I was in hospital and I couldn't attend the mini think tank, I submitted these contributions in writing as part of that process.
Sorry, I missed that.
As I said, this was the report that was given us for the purpose of the mini think tank, which I missed. In order to, because I wasn't there, I made written contributions to the report instead of sitting around in a room. So these are my inputs for the mini think tank.
Okay. Why did you not tell the committee that when I asked you about your involvement, you said, except for one meeting which you missed because you were in hospital?
No, I did. You can check it.
Just finish up, Mr. Van Merwe, and then I go to Advocate Bauer.
No, I was referring to exactly this in my evidence on 2 occasions, in cross-examination and in my evidence in chief, saying that because I wasn't there, I made submissions in writing to Mr. Kekana. It's not true that I didn't refer to this.
Okay, that's fine. That's fine. If the record will speak for itself, and if that's not correct, then I apologize to you.
Just to pause that with both Advocate Bauer.
Just to point out, it's a paragraph 34.8 of his affidavit as well.
Okay.
Yeah, well, okay.
Okay, thank
Can I
you.
move on? Yeah.
Proceed.
Okay. The point I want to make there is that you made a, let's call it, or some significant contributions to the CX document, correct?
Let me put it this way. I highlighted. No, I'm not comfortable in just saying yes or no. Because
Pardon?
I'm not comfortable in just answering yes or no. This was an executive summary.
Nobody said you must answer yes or no, Mr. Van der Merwe. You can put it on as you've done all day. Answer long question, answers as much as you want.
Thank you so much.
Can you conclude what you're saying, Mr. Van der Merwe?
This was an executive summary of the report. First of all, it was not the report. So to say I made a significant contribution to the report. What was given to us was a summary and an introduction. It didn't even have remedial action at the time. And the focus of my inputs here, and I would implore members to read it carefully, was on how the issues were identified and whether I was actually cautioning of going into the lifeboat transaction itself. I was saying that for the purpose of jurisdiction and our involvement here, we need to focus on the issue at hand that's within jurisdiction, knowing full well that Section 6.9 was an issue going to anything prior to 1995 and even 2 years earlier. So read my inputs carefully here in terms of how I was directing. And there's no indication again. I made substantive observations. None of these observations were even taken into account or found its way in the narrative of the final report. So I'm not even sure if this was read by any of the members. But the risks that I point out and the way in which I described it here, to say that we don't need to make a finding because it's already been disturbed, it was not adhered to in the final report. So none of the things that I said here found its way again into the final report.
Okay. You accept, don't you, that one of the recommended actions in that draft was related to changes in the regulatory framework or the policy framework?
Checking?
Yes, no. No, you don't have to look at it. I'm just asking if you, in your memory, that there was an issue to do with that.
No, the remedial action here was just directed at the Reserve Bank to ensure that systems are in place. It was not anticipating changes to the regulatory framework.
Okay, so when you say to ensure by means of introduction of internal policies and regulations that similar circumstances are avoided in the future, that had nothing to do with the regulatory framework.
In the context of the preceding questions, this was a remedial action directed at the Reserve Bank, not the overall regulatory framework.
Yes, but okay, and so was your recommendation also directed at the Reserve Bank Act, wasn't it?
Not necessarily. We haven't even touched the Reserve Bank Act at the time.
What do you mean you didn't touch? Didn't your recommendation say public protector therefore supports the call that the Constitution and the Reserve Bank Act should be reviewed and amended? Is that not touching it?
Yes, but in the context of this remedial action, we, as I said, this didn't even find its way into the report.
Okay. Anyway, let's go back to your letter. Okay. All right. Yes, I read to you the quotation from the EFF case, and then the fact that you are saying the what I call the crux of the matter, referring to the accountability mechanisms and so on. Sorry, just yes. But because of the time, I'm sure the chair is going to release us soon. The last sentence of it looks like he's about to do it. The culmination of your letter is this: we trust that our submissions will be of assistance in guiding the committee deliberations on reviewing, as explained before, the Constitution aimed at strengthening our constitutional democracy. In other words, that was the punchline of your recommendation, that there should be this constitutional amendment to strengthen our constitutional democracy, correct?
No, sir. This was not a recommendation. It was a draft put up. I did not sign it. I did not put it as a recommendation to say that this was the final recommendation. This was a discussion document. You're trying to
a discussion document.
Stage
I'm reading from the letter now. I'm sorry.
Yes,
I'm sorry if I confused you.
The wording here was proposed. It was not even discussed whether it will be accepted or not accepted, whether this was in, to now attach a way to it and say this was in fact my recommendation to the public protector, while this was just even as an avenue proposed as we didn't even deliberate on this, whether it was in line with the public protector thinking.
No, Mr.
No,
Chair,
I am.
No, please, just listen, please. I'm saying to you, I'm not saying what you're saying. I didn't say about any recommendation to the public protector. I'm talking about Mr. Nzimande and Smith, to whom the letter was addressed. Okay? I'm saying to those people who were the co-chairpersons of the Joint Committee on Constitutional Review, the punchline of your letter was that we trust, when you say we mean the Public Protector of South Africa, not Advocate Mqobane, the institution, correct?
No, the signature was going to be the public protector.
Yes, but not as Advocate Mqobane from, I forgot the name of that place, Kwaggafontein. But yes, but as going to be signing there on behalf of Public Protector South Africa, correct?
Correct.
And every time you, in your evidence in chief, and even now when you say the Public Protector will do this, revision this and that, you don't mean her as Busisiwe Mqobane from Kwaggafontein. You mean as Public Protector of South Africa, correct?
Correct.
Yes. Okay. So that's the context in which you use the word we. We trust that our submission will be of assistance in guiding the committee's deliberations on reviewing the Constitution aimed at strengthening our constitutional democracy. You and I earlier agreed that the notion of reviewing the Constitution encompasses the amendment that you proposed, correct?
I didn't propose an amendment, sir. The word proposed means that this was accepted and endorsed. As I said, this was just an avenue. The way in which you are trying to attach to these documents as having informed decisions while they were draft deliberative documents, I can't attest to that.
Okay, this is my last attempt before the chair does what I can see is eager to do. You are saying that these 3 preceding pages where you give the motivation, you give the Constitutional Court quotations, you give the relationship with the poor and so on. All that had nothing to do with that last sentence that says, we trust that our submission, in other words, all this stuff that has been in the previous paragraph, will be of assistance in guiding the committee's deliberations on reviewing the Constitution aimed at strengthening our constitutional democracy. Can those 2 things be divorced?
No, and that's not what I'm contesting, Chair.
Okay, therefore, you agree with me if the 2 things cannot be divorced from each other. You agree with me that the punchline, and I'm just using that word loosely, of the letter that you drafted was that whatever has been said here will guide, let's not put it even higher than that, the amendment of the Constitution.
Yes.
Thank you. Okay, I've been standing on the way of the chairperson. So I think that on that topic, if my next issue is quite a long and complicated one. So it is. So I think we should start on that one in our next session.
Well, thank you, Advocate Mpofu. I would not have stopped you, so you have called for time out.
No, Chair.
And I oblige.
I'm ready to proceed, Chair. You know me.
As I always do. So
I can go on until midnight.
I did reclaim my precious hour and more for the day. So
no, I'm ready, Chair.
There would not have been time kind of lost in that regard. So with that, colleagues, we will pause there for today, continue tomorrow and finish tomorrow.
Chair, sorry. Sorry, I don't want to cut you. I don't know if the discussion that Ms. Bauer and I had around starting time has been communicated, or whether you're going there.
No, there's no starting time communicated to me.
Yeah, we were proposing earlier start, maybe even 9:30.
Advocate Bauer?
We have no difficulty if you want to start at 9 or 9:30. It's Friday tomorrow, and members might want us to start earlier. I don't know if that's in an endeavor to finish earlier or an endeavor to have more time.
It's an endeavor to have more time.
Well, I've already, the issue of time is, I'm in control of that. So it's not in the back room. We just indicate that. So the program would have indicated today and tomorrow and would have agreed at 10 with the members. I don't think there's a problem in asking that we be here 9:30 or do you want to stay at 10? But we continue tomorrow and conclude tomorrow with our work. You fine with 9:30, 9:30? Colleagues, thank you. The meeting is adjourned. We'll resume tomorrow 9:30.
Thank you, sir. Thank you very much, sir.
Obliged.
Oh, thank you.
As I always do. Thank you.
No, you haven't obliged, sir. I wanted to go until 12.
I stopped. I didn't stop you. Advocate Bauer?
There was an issue of corrections that I had left in abeyance, which I have endeavored to speak to Advocate Mpofu today, and he has yet to revert to me. We need to sort that out before we commence tomorrow morning so that I can communicate with Advocate van der Merwe tonight. So we need to do that.
I leave that to both of you. Thank you.
Thank you, sir.
Thank you to everybody. The meeting is adjourned.